ready? Okay, good afternoon. My name is Lizwe Jamela. I'm the Programs Manager of Veritas. As you may be aware by now, on the 24th of May 2022, the Constitutional Court delivered a judgment that a lot of people have been talking about. This is the judgment by Diana Eunice Kawenda versus the Minister of Justice and Legal and Parliamentary Affairs, as well as the Attorney General and the Minister of Health and Child Care. So the judgment has received a lot of attention, and it's the so-called judgment that deals with the age of consent for minors for sexual activity. Maybe before I talk much about the judgment, I just want you to understand that this is one of the many successful litigation endeavors that Veritas has done in partnership with Tendai Biti, assisting us with legal services. So this is one of the cases which was actually a follow-up to a case that we did where the Constitutional Court in 2016 delivered a judgment outlawing child marriages. So we saw it fit to go back again to the Constitutional Court to deal with the issues that relate to the law that pegs, that distinguish children in terms of their ages when it comes to sexual consent and sexual exploitation, which is not consistent with Section 81 of the Constitution. But I'm not going to go further in terms of the judgment itself at this moment. I'll let Mr. Tendai Biti take us through the judgment, as he is the man who actually did the arguing in the Constitutional Court, resulting in this landmark judgment that everyone is talking about, so that at least we understand exactly what exactly is the judgment talking about, and what is the effect of the judgment when it comes to our law and our minors in Zimbabwe. Over to you, Mr. Biti.
Thank you. Good afternoon, ladies and gentlemen. We are very pleased to be holding this press conference on a very important issue, the issue of protecting women, the issue of protecting children. So let me begin by explaining the background to this case. As Laz was saying, you recall that on the 16th of January, in the year of our Lord 2016, the Constitutional Court declared child marriages unconstitutional. This was in the case of Loveness Mudzuri and Ruvimbo Tsopodzi that we brought on behalf of young girls in terms of Section 85(1)(d) of the Constitution of Zimbabwe. So the Constitutional Court outlawed child marriages. That is to say, the marriage of any person below the age of 18 was outlawed. But there was a challenge. There was a challenge in that whilst the age of marriage was now defined to mean 18 and above, consistent with the definition of a child in our Constitution. Our Constitution in Section 81 protects a child, and our Constitution defines a child as anyone between the age of 0 and 18. We had a challenge, and the challenge was that whilst there could be no marriage before the age of 18, the law allowed sex. The law defined a young person as anyone from the age of 16 going upwards, and the law in Section 70 of the Criminal Code permitted a young person to have sex. So we felt that there was a lacuna in the law, in that there could be no marriage with a child, of a child, involving a child below the age of 18, yet a minor, 16 and above, could have sex, which created an anomalous situation. And when we argued the child marriage, case, Justice Bentler Chua kept on asking this case that, but suppose I want to marry a child who is 16. The law says I can't marry that child, but the law permits me to have sexual intercourse with that child. So because of this gap, our victory in the child marriage case was Pyrrhic, as long as the man were allowed to continue ravishing on babies, on children. So we delayed a bit because we thought that the government would actually come up with legislation that would harmonize the constitution with Section 81 of the constitution. We thought the government would quickly move in to enact a law that not only outlawed child marriages, but also altered the definition of a young person from 16 to 18, consistent with the constitution. Of course, this didn't happen. So we started working on this case. There were a team of lawyers from this firm, and I want to mention in particular Vimbai Tavaziva. She spent hours researching on this case, and I want to express my indebtedness to her. I also want to express my indebtedness to Professor Susan Ross and her students at Georgetown University, who also assisted us with research. I want to thank as well some of the interns we had in this firm who actually worked on this case. One of them is Mr. Farai Benure. So when we did the application, the legal work, I want to thank Veritas for coming on board with helping us with the legal fees. Litigation, as you know, is very expensive. So we argued that this case last year in November, 16 November of 2021, and judgment was handed down, as all of you know, last week on the 24th of May 2022. This judgment is far-reaching. This judgment is far-reaching. The net effect of this judgment is to outlaw Section 70 of the Criminal Code. So it alters the definition of a young person. It says young person can be a person who is 16. Young person has to be defined consistent with the Constitution, which means a young person is 18 and above. It also then says all the provisions of the Criminal Code and their main, which relates to the age of sexual consent, are now repealed. But more importantly, and this is where I'm most excited, it gives the government time to come up not just with a simple alteration of the provisions of Section 70, Section 72, Section 75, Section 76, Section 78 of the Criminal Code. It actually obliges the government in the next 12 months to actually come up with a comprehensive Child Protection Act. When we argued this matter, we argued that we needed a comprehensive act to protect children. So number one, protecting children against sex, not just sexual exploitation, but against sex. To protect children against child marriages. You know that the Marriage Act has not been passed, the marriage bill has not been signed into law. So as a matter of fact, even though child marriages were outlawed in 2016, we actually don't have a law that protects children. This law must also deal with the difficult question, of what are called Romeo-Juliet situations. What happens if a 17-year-old goes out with a 17-year-old? What happens if a 19-year-old goes out with a 17-year-old? The law must deal with that, because we can't pretend that children are not having sexual intercourse amongst themselves. But the law must answer that. So one of the reasons why the government has been given time is so that, and I argue that the government needed time to consult experts, to consult various NGOs which would deal with children, to consult the children themselves, to look at comparative studies, to look at comparative laws across the globe. South Africa being a very good example, which we should look at. How do we deal with children who are having relations amongst themselves? But it's not enough just to protect children in their sexuality. There are also other things that are challenging children. For instance, cyberbullying, for instance, pornography, for instance, the issues around laws on guardianship. There are also questions that are not answered, hard questions that need to be answered. The law says a child can't have sex now. The law says a child can't have marriage. What happens if that child has sex and is pregnant? What happens if the child is raped and is pregnant? Because Section 3 of the Termination of Pregnancy Act imposes restrictions. So the onus now is on the executive, the onus is now on Zimbabweans to answer these difficult questions, which will require a lot of research, which will require a lot of hard work. I'm glad that Veritas is going to work on a child bill. I hope it does that. One of the things that is also problematic is the situation of children on divorce, the situation of children on guardianship, or the situation of children on inheritance. You still have laws in Zimbabwe that says a female child can't inherit from his father's estate in a customary law context. So there is a lot that needs to be researched on. There's a lot that needs to be worked on. So I hope that they will move with speed. I hope that the concerned NGOs who work with children, international bodies like UNICEF, organizations like Veritas, I hope they can work to come up with this draft bill. They can tap in on some of our expertise, but it's important that the government deals with this issue as a matter of urgency. Because of poverty, child marriages are actually on the increase. Since 2016, child marriages are actually on the increase. And I can tell you, despite this judgment, sexual intercourse with children is actually going to increase. So children abuse is actually increasing, notwithstanding this unhappy situation. Do you know that across the world, there are at least 15,000 child marriages every day across the world? Do you know that there are at least in Zimbabwe 6 abortions that are taking place every hour in Zimbabwe, and most of those relate to children? So our children need to be protected. There is a question that I see being misrepresented on social media. The Constitutional Court set aside Section 70 of the Criminal Procedure and Evidence Act and of the Criminal Court. The Constitutional Court suspended, as it has suspended its ruling, not for the purposes of amending the law, but for the purposes of allowing government to come up with a comprehensive bill. Does this mean that a man can just walk and sleep with a 16-year-old child at the present moment? I think you face the danger of actually being charged with the rape. You face the danger of actually being charged with the rape, which is not statutory. You remember, statutory rape is when the 16-year-old child or below consents. So you actually now face the danger of actually being charged with rape. I was speaking to some prosecutors who have considered the judgment and considered the transitional position. So this judgment is not a license that men can continue ravishing children and our daughters between now and the next 12 months. It's not. This judgment is just given government leave to amend, to come up with a comprehensive child protection law in the next 12 months. So my understanding is that you can't have sex with a child. You can't have sex with a 16-year-old. However, the government has to come up with a comprehensive law. So I saw a lot of distortion. If you touch a child, beware of being charged with rape. And I hope men out there, terrible men out there, are listening to what I'm saying. So finally, let me thank the Constitutional Court for a very a brave, judgment, far-reaching, judgment. And I'm glad that Justice Makarao wrote this brave judgment. When I was arguing, she kept on asking me whether the Constitution protects children against sex or against sexual exploitation. And I kept on arguing that sex itself is a demon and children need to be protected against it. And I'm glad in her judgment she agrees with that. We can't have men ravishing on children, but the judgment alone is not enough. The judgment alone is not enough. So we appeal to authorities, particularly the government, to come up with a decent law as a matter of urgency. We appeal to community leaders. We appeal to traditional leaders. We appeal to various religious sects to protect children. We appeal to parents. We appeal to relatives. Do you know that 20% of the rapes and the sexual abuses that actually take place in this country, they actually take place relative on relative, an uncle abusing a niece? So we appeal to families to protect the children. The government, community leaders, traditional leaders, church leaders, families, let's protect children. I thank you very much. I will answer any questions.
Thank you. Maybe before we take questions, like Mr. Biti already indicated, as Veritas currently now that this judgment is out, we are now working towards drafting what we call model bills that will then lobby and advocate for the government to adopt, also after consultation of other experts that know about these issues. And maybe just before we take the questions, I think I need to emphasize, Mr. Biti was pointing out Section 70. I think for the avoidance of doubt, people need to understand that there were two issues that stemmed out of Section 70 of the Criminal Law Codification and Reform Act. The first issue is the age, because the Criminal Code defines a young person as someone who is below 16 years, which is an issue because it's not consistent with the Constitution, which defines a young person as someone who is 18 and above. The second issue in terms of that law, maybe let me just read out. The offense that was made by that section is of having extramarital sexual intercourse with a young person. So what it simply meant was that any person would have sexual intercourse with a young person, and the defense that was available in terms of that criminal offense was that I'm married to this young person. So in essence, what then this judgment does, like pointed out, it not only deals with the issue of the definition of a young person, but it also speaks to the issue of the defense of you saying I'm married to a young person by simply, in other words, abolishing also a marriage with a young person as well, which is also an extension to the 2016 case of the Muturi case. So this is more of the Constitution actually re-emphasizing the issue and making sure that our law does not make it a defense to say I'm married to a young person, then we get away with that. So I think we should be very clear, and also as reiterated by Mr. Biti, to say the Constitutional Court did not necessarily, because now what is happening out there is people are saying the Constitutional Court has maybe like changed the age of consent to 18. The Constitutional Court has not said that. The Constitutional Court has simply identified sections of the Criminal Law Codification Act that are not consistent with the Constitution. That now it's now the duty of the legislature to come up with a comprehensive law that then deals with those gaps. But as it stands, the Constitutional Court, its duty is to interpret laws. So what it has done is that it has interpreted the provisions of the Criminal Law Codification Act as against the Constitution, Section 81, for instance, in this case. And it has held that these provisions of the criminal codification that relates to the age of consent, that does not protect a certain group of young persons, that is between 16 and 18, when the Constitution is clear that all children needs to be protected. That is to say, any young person who is below the age of 18 needs to be protected. So now the law has to be comprehensive in its protection. And also maybe I need to comment, there's been questions that relates to what then happens when it comes to children wanting to access sexual health related facilities. Will the policy makers and institutions not say no, since the Constitutional Court has held that you can't have sex, but then why are you needing services that relates to sex? I think that is where now then the policy makers have been given 12 months to come up with a comprehensive law that deals with issues that relates to sexual health even for children as well. In as much as sex within children may not be desirable, we cannot look away and think that sex among children themselves do not happen. So now it's a question of now, that is issue that the Romeo and Juliet issue that Mr. Biti was talking about. So now the government and the parliament has to come up with a comprehensive legal policy that speaks to those issues so that we have a comprehensive protection of children in terms of the law. So having said this, we can now take any questions that you may seek for purposes of clarification or any areas that are confusing in terms of this judgment. Thank you. Does it mean it was very clear? And
so I had someone, I saw on social media someone saying this judgment means that children also should not have sexual education. So they want to ban biology lessons to children, because biology lessons talk about sex. I mean, that's absolutely without merit and without foundation. Education is education, including education on reproductive rights. So we hope there won't be change of any curriculum. But as I said, this is a far-reaching judgment. Let me also say that, and I should have said this, that when we do these things are very difficult to do. They require a lot of research. The drafting is a lot of pain. So sometimes it's a labor for love. You sit in a cold library. So it's very humbling when the judgment then come out, because we're not doing it for anything but for people, for poor children out there, for poor women. So I want to say that it's very humbling to be able to do these things with the results that we get, and I want to express my humility, my gratitude to the fact that we're able to do this time and time again in these very big cases. It's a very humbling experience to be able to do this, and particularly for my firm, Tendai Biti Law. We're a very small law firm, but to be able to generate these precedents, year in, year out, it's a very humbling process, but it's a lot of hard work. It's a lot of hard work. There are easier ways to make a living. This is not one of them.
Okay, any questions? Looks like
thank you very much.
We are now content and very clear about the subject matter. Okay, thank you. If there are no questions.
Judgment Munaya, is
okay, so if we don't have questions, I think we'll say
this press conference. I'm having your numbers. Put your numbers here.
For those who need hard copies of the judgment, Valentine can provide in our court.